Good afternoon, everyone. Welcome to Cubase training series. My name is Dan Zhang, and I'm Director of Marketing and BD at Cubase Center. Today, we are going to have an educational seminar on intellectual property with 4 experts from well-known law firms. Before we get started, I'd like to give you a brief introduction of Cubase and our co-organizers. Cubase Center was founded in 2018. We aim to build up a global platform to connect innovation and entrepreneurship. Over the next 2 years, after we purchased a commercial building in Silicon Valley, we reconstructed the building to support business innovation in the life science industry. Cubase is roughly about 112,000 square feet. Inside, we have office suites, biomedical labs, co-working space, event center, and large sharing spaces. So far, we have attracted almost 40 companies to build up their business at Cubase. Companies in our community not only have access to our world-class facility, we also provide many events and programs like monthly educational seminar, quarterly startup pitch events, annual accelerator program that aims to help promising startups scale efficiently and effectively in the global market. So for today's event, we also have 2 co-host organizations. The first one is HISTA, aka Hawaiian Science and Technology Association. HISTA was established in 1999. It is a leading nonprofit organization that empowers Chinese American entrepreneurs and leaders. And another partner for this event is LEAP. LEAP is also a nonprofit organization. They closely connected the community, featuring aspiring scientists and scholars, entrepreneurs and investors, professionals and industry leaders. So here it's about the speakers of today's event. So I will leave the time for our speakers to introduce themselves. And first, let me give a quick introduction of our moderator, Lake Dai. Lake is the chairwoman and president of HISTA. She is also the partner of a local, well-known venture capital company, LDV Partners. Also, Lake is a professor from CMU University. So Lake, I'll give it to you from here.
All right, thank you, Dan, for the introduction. I'm actually also an inventor as well. So I was just sharing with the group that I have 5 patents. Experienced how important IP is. So I'm really glad to have the opportunity to host this event. All right, so with that, what we're gonna do is that we will do a brief introduction of the panel speaker. We have Ali, Joshua, Michael, and James here. So what am I going to do is have each of you to talk maybe 1 minute or 2 about your experience, particularly how it is relevant to IP. So why don't we just go with Ali first?
Great, thank you so much, Lake, and nice to meet everybody. I'm a partner at Wilson Sonsini. I've been at the firm since 2008. I've been doing patents for 16 years. My background, I'm a scientist by trade, if you will. Got my PhD at Stanford many years ago, and after a postdoc at Harvard, went into patents in 2005, and I've been doing patents for over 16 years. My focus is mainly in the life sciences. I help companies very early stage to get patent strategies in play, which includes getting patents on file, and also helping them navigate the landmines out there. And in the life sciences, depending on what you're doing, there are many landmines out there, could be, and this goes into freedom, what's called freedom to operate. I help with companies very early stage through financings. I deal with investors all the time in terms of getting companies financed, help companies go through the acquisition or going public. And I work with companies, whether private or public, all the time, and helping them get patents that are of value to them, and also helping them navigate sort of the space, and helping make sure that we can help them to block this space as they move towards commercialization.
That was great. All right, thank you, Ali. So Joshua.
Welcome, everybody. You were able to join us. It's my pleasure to be here. I'm Joshua Goldberg, co-managing partner at Nath Goldberg and Meyer. We're an IP boutique law firm based in Alexandria, Virginia. For those of you who don't know, that means we are a medium-sized firm that only focuses on IP or intellectual property. What does that mean? It means we specialize in turning our clients' inventions, ideas, and innovations from intangible ideas into a concrete property right or registration that you can then use to defend your markets, to gain funding, and to generate licensing revenue. I manage my firm's chemical, pharmaceutical, and biotech practice. And the reason why I'm able to do that, similar to Ali, I have a science background. I have a chemical engineering background, and I worked in industry for a little while doing drug composition work. I worked for a very small company out in St. Louis where big pharma, people like Pfizer, Merck, and that sort of company would come to us and say, hey, we developed a new cancer drug or a new stomach drug. Please tell us how we can get it into a tablet or a capsule and terracoat it so that it gets into the intestines, whatever it is, which was a wonderful experience. I would not be anywhere near where I am now without having learned that. I've been with my firm since 1997. I've been in patents that long as well. So what is that, about 24 years now? And I look forward to sharing some experiences with everybody.
Yeah, that's great. Thank you, Joshua. Michael.
Thank you so much, Lake. Thanks for having me. My name is Michael Kreiner. I am a mid-level associate in the intellectual property group at Pillsbury Winthrop Shaw Pittman in our Los Angeles office. I have experience across IP through patent, trademark, and copyright work. Unlike my fellow panelists, my focus is not so much in the life sciences and patent space. I'm not an engineer by trade. I came to the law via a career as a classical musician. And so the focus of my practice is in the trademark and copyright space. A lot of my trademark work involves clearance and advising for trademark prosecution as well as trademark litigation. So it's a pleasure to be here speaking with you today, and I look forward to the conversation.
All right, thank you, Michael. Last but not least, James.
Hi, I'm James Huey. I'm a corporate partner at Wilson Sonsini. I have an undergraduate molecular cell biology background, but I chose not to go the technical or PhD route. And I went to law school, and for the last 16 years, I've been representing companies on the corporate side. So I'll help them get formed, funded, sell side M&A, and IPO. The good thing with my background is I do at least track the milestones of the companies that I represent. And then later on in M&A or IPO, I could provide the terms and customize the language because I do understand the technology of my clients. Nice to meet everyone.
This is a tremendous, really, really knowledgeable panel. We have experts from large law firm. We have a specialized law firm in IP. We have specialized law firm in copyright, and then we have corporate representatives, right? So that will give us our angles from a different aspect. And the other thing I actually want to add to it, in addition to Dan's introduction, is that I am a partner at a deep tech VC firm. So part of my work is working with our portfolio companies to look into what are the areas that are patentable. And quite often we actually struggle, okay, which country we should go first, right? Should we go international? How do we protect our IP? And the other role of me is I'm an adjunct professor at Carnegie Mellon. So I teach applied AI. And because there are so many, from both teaching and research perspective, we have a lot of new projects between faculty and the students. And then we also constantly talk about IP and then how much that should, and then we work with the patent office in the university as well, to the extent that it is so important. I actually went back to Stanford, took the IP class last year. So I'm really excited. I think this is a great opportunity for anybody who are either a founder or an investor to evaluate the IP value, or corporations think about and continue to protect your own innovations. So with that, I want to say that today we have limited time. What we want to do is that we want to cover 4 important segments. The first part is the definition. So what is the IP and why is it important? And then we'll talk about how IP are created, how do we do due diligence, and then we'll talk about how do we protect our IPs. And last one, and we'll talk about how we monetize after we create a valuable IP portfolio. So with that, I'm going to start with the first 2 questions to Ali. The first question is, what is intellectual property and what is the patent, and why should a company pursue patent protection?
Sure, that's a fantastic question there, Lake. You guys can think of it this way. You have physical property, which is my iPhone, whatever, my car, scooter, whatever. That's physical property. IP is these intangibles, that are ideas. And for example, an invention. It could be a word, a marking, lines of code, and so on. But there are things that are of intellectual nature, and those things, there are ways that the governments have found to allow us to protect them. Patents are intended to cover things that have some usefulness, utility, or design aspects. So these are inventions that do something, and I'm sure all of you have those. Maybe you think about them, and you may even already have patents on file or whatnot. But patents cover the usefulness, the functional aspects, the design, and so on of an invention, and there are different ways of protecting those. Trade secrets sort of are there as well, which are directed to protecting ideas that derive value commercially to a business from being kept as a secret. And that requires that anyone that has access to those inventions or ideas, customer list, lines of code, whatever, whatever the secret is, anyone that has access to it has to know that it's to be kept as a secret and to not be shared with anyone outside of the company. That's a trade secret. Then you have copyrights, which protect lines of code. All of us scientists and engineers, I'm sure at some point have had to code, and your lines of code are protected by way of copyright, which is the exact manner in which the lines of code are put down in your favorite compiler or whatnot. And then you have trademarks, which protect a company's name, for instance. Google and whatnot. Cubase itself may be protectable by way of a trademark, but it's the name itself or the look and feel of that name. The trade dress is another means to protect that. Those are the 4 types of ways of protecting IP here, and as well as other countries. Like patents are not just in the US, but they are also in other countries. Various countries in Europe, China, Japan, and so on do offer patent coverage, ways of protecting inventions through patents. And the important question is, why get patents? Who cares about patents? Why even bother about getting, hiring a patent lawyer like us here to help you protect that? And the answer is that you can certainly keep your ideas as a secret. But the downside of a secret is that once the invention is disclosed publicly, whether it's through whether it's through someone stealing it from you or someone else independently developing it, once it's made public, your trade secret evaporates. It goes away. It's gone. And you have no way really, unless it's someone stole it from you, and that can get very tricky. But if someone didn't steal it from you, but it happens to be the case that a competitor just came up with the same invention themselves and they published it, then you have no way of getting any sort of damages back. You've lost that. Patents, on the other hand, are a very nice way, a very powerful way of preserving value in your ideas. With patents, when you file them and you get those patented by working with us or Joshua's firm or whoever, picking a good lawyer to help you with that. Once you get a patent and someone is doing what the patent says, you can use that to stop them. Has to be done very carefully, but you have that option. And so patents are a very nice, somewhat tangible way of preserving value for your companies. And in the life science space, patents are not just an option, they are a critical need. You must file patents if you can. Some inventions certainly lend themselves to being kept as a trade secret, like you may have a very specific algorithm for classifying samples as cancerous. Keep that as a trade secret because the algorithm may be too specific for a broad patent. But for if you're a therapeutics company, your favorite target molecule that you guys are planning to run through clinical trials, you must file a patent. Word must cannot be emphasized anymore. You have no option. You have to file a patent because your investors expect it, your future big pharma acquirers expect it, the public expects it. There's no other option. And you must do that to preserve value for your company as you go through financing to an M&A or an IPO. So it's a very big need for companies in the life science space.
Yeah, that's great. Thanks, Ali. And I'll come back to you if we have time for some examples. I think that will be, just talk about how important it is. It's not even as impactful when you actually talk about some numbers and then some of the good examples and bad examples. Okay, so with that, and I actually want to ask a few questions to Joshua. So now we know that it's very important to file patents, and then here come the questions of how, right? So how do you perform a patent due diligence review, and how do you build up, how do you even create a patent, and how do you build up a patent portfolio to increase our business value?
Well, thank you very much for the questions in the introduction, Lake. A lot of this will come from what Ali started with. So number one, of course, you want to work with a patent attorney, whether it's myself, Ali, James, or someone from another firm. You want to work with an expert in the field who knows what they're doing. No different than when you're doing your science and your discovery, you want an expert in what you're doing to look at it. You want an expert in the patent process to help you as well. Now, when it comes to what to patent, how to build a portfolio, the way I look at it is anything new that you're doing is a potential patent or a potential patent application. It doesn't have to be groundbreaking. It doesn't have to be earth-shattering. It's anything that you're doing that's different. So what we like to do when we start working with a company or startup is we do what's called an IP MRI. We come in and we talk with people. It used to be a lot easier when we were in person. Now it's all done by Zoom, which can be a little bit harder, especially when you're dealing with multiple people in the company, but it's still doable. And it's a matter of just asking everybody, what are you doing for the company? What are you working on? Are you working on manufacturing? Are you working on research and development? What are the things that you're doing? And we develop a punch list, a hit list of all the different things we're seeing that are potentially patentable. When we're done with this process, we come to the owner of the company, the CEO, the GC, whoever it is, and we say, look, we talked with everybody. We found these 10 different ideas that we think might merit filing a patent application. We know that you have room in your budget and time for all 10, maybe 3, maybe 7. Let's go through the process, see what they are, and pick the ones that make the most sense for you to try to protect right now. Some of them can be foundational technologies. Some of them are very specific, a new amino acid sequence or something like that. It doesn't have to be, again, everyone thinks about the big technology, the big innovation that isn't limited in scope. And sometimes you do want that. But when you're building an IP portfolio, you do really want patents of varying scope. You want something that's really big and broad so that you cover everybody who might try to compete with you. And you also want something very narrow so that nobody can do exactly what you're doing.
Well, I think that sounds like a good strategy, assuming that you have the budget to do it, right? Then the question I have, I'm going to extend this question, actually talk, particularly to James, because as a corporate legal team, right? And then you have to consider the budget. So let's say if you are consulting for your client or your internal client that they want to build out a portfolio, but like Joshua said, that you can build a really broad, large, and also very specific patents in a whole family. But let's say if you have a budget, then what are you going to do?
Yeah, so that's where on the financing side, I'll work closely with the patent attorney because and the company, because the company and the patent attorney will scope out a budget that they're not going to do the full patent portfolio at the outset, but instead I've seen it where they'll build the patent portfolio over time. So initially, maybe they'll file a provisional or an initial patent, and then as the company raises more money according to the budget, then the patent strategy and patent portfolio is built out. So oftentimes we'll work there. But the reason why I thought I'd join the conversation is that oftentimes I'll have companies or CEOs that might be only thinking about things in like a tech perspective, and they say, "Oh, I'm going to go out and talk to some investors and do some pitch competitions," and they might disclose their secret sauce or their targets or things that are patentable, and then that's where I put my head in my hand and say, "Oh no, you should have talked to patent colleague. This is not an enterprise software company. This is not even a medical device company. This is a biotech company that you really need to talk with some of the Ali, Joshua, others and Michael before you go and disclose your unpatented technology." So that's why sometimes it comes to my desk, and so it's important that really the first stop is the patent.
All right, so Ali, so when James approached you, assuming it was the example, James approached you with some ideas, what's your strategy of helping him to creating this portfolio of patents?
Yeah, and I thought Joshua put it very nicely. It's basically at the heart of it is there something new here? And let's forget about obviousness, guys. Forget about it. Just worry about, is there a difference? Are you doing something new? And most, if not all of you, probably do have something new. That's why you're here. There's something there that's special. Let's talk about what's special there. Let's get the full details of what makes you special. What are you pitching to investors to get financing? What is your go-to-market strategy? That special sauce is what we want to better understand, to take it apart down to the atomic scale, to understand every bit and detail about it, at how everything works at the molecular level, the biochemistry, everything. We're all scientists here, so we can go down to that level with you. We're not just your standard lawyers here. We are all scientists. We can understand that, and we do want to understand that. We need to understand it. We need to be you, because we are representing you at the patent offices, and we need to be able to get you patents that cover what you are planning to do commercially. And so the first step is, let's talk about your ideas. And once we've talked about those ideas, then as Joshua pointed out, we'll find a way to structure ways to get you broad coverage, mid-scope, mid-scope coverage, and so on, to help you own your space.
Yeah. So I think we talk about how IPs are created, and then I think we should actually talk now. I want to give Michael an opportunity specifically talk about copyright. So Michael, Ali touched on this already at the beginning, is that there's a difference between trademarks and then from other patents, and then can you actually expand a little more, and particularly can you talk about how companies can protect their own brands from the very start?
Yeah, absolutely. Thank you. So I guess we'll start with what a trademark is, and then we can talk about some of the differences between a trademark and a patent. So a trademark is an exclusive right to use a mark that's going to distinguish your goods or services from those of another business. And trademark law in general is pretty intuitive. I'm sure that everybody on the panel and attending has some intuitive understanding from our daily lives of what a trademark is and how it functions. Typically, a trademark is going to show up as a brand name, a logo, or a slogan for a business, but trademarks aren't limited to those categories. So a good example is with a company like Nike. Nike is going to hold a registered trademark for their brand name, Nike. They're going to hold a registered trademark for their logo, the swoosh that we're probably all familiar with, and also for their slogan, "Just Do It." In addition to those categories, trademarks can include things like colors, sounds, smells, the packaging, or some other non-functional design features of a good or service. Some more examples, a registered trademark for a smell, which is very, very uncommon, but it does come up from time to time. In 2018, Hasbro was granted a trademark for the scent of Play-Doh. There are also registered trademarks for sounds, things like the NBC chime that we hear on TV, or the roaring lion that we'll see before an MGM movie. Colors can be registered as trademarks. Some examples are Tiffany blue or Target red. And the purpose of all of those trademarks is to act as a source identifier, to allow the consumer to know who is the source of that good or service, what business is providing this to me, and to avoid confusion between one business and another. So a practical difference between a trademark and a patent, a very easy one on the surface, is the duration of each of those areas of intellectual property. So a patent is going to exist, and it's going to provide a limited monopoly to the inventor for a statutorily created period of time, generally 20 years for a patent. Trademark rights, in contrast, if they're properly maintained, can exist in perpetuity. A business can hold on to their trademark rights forever, provided they continue using their trademark as a trademark, and their goods or services are continued to be distinct, and that trademark is continued to be distinguishing their goods and services from those of others. So that's just kind of a very surface level difference. But if we get into a fundamental difference in what the purpose of a trademark is versus the purpose of a patent, and Ali gave us a really good preview of the purpose of a patent, to create a limited monopoly for an inventor. The inventor has an exclusive right to sell or to use or make an invention for that specified period of time. And the US government has an interest in this and grants patents for the purpose of encouraging inventions that are useful to society. They were trying to solve technological problems, and by giving that exclusive right, incentivizes those problems to be solved by individuals or by companies. Trademarks have kind of a dual purpose. One of those purposes, as I mentioned before, is to protect consumers, so that consumers aren't deceived as to the source of the goods or services that they're purchasing. So that, in other words, if a trademark is acting as a source identifier, the consumer can be reasonably certain when they see the trademark in association with the goods or services that they're buying, that the goods or services come from that owner. But another aspect of trademarks and the purpose of trademarks that's, I think, more useful to startup businesses to be concerned about is that it protects you as a business, as the owner of the trademark, by prohibiting competitors from taking advantage of the goodwill and the reputation that you've developed in the marketplace through your goods and services. And that kind of goes into, I think, Lake, the second question that you asked about, from the beginning, the concerns that businesses should have. And a lot of that concern is protecting your consumer base and protecting your goodwill and your reputation. So one of the primary ways that we're going to do that is by registering your trademark to prohibit other users from coming in and using similar marks or deceptively similar marks to your products.
Yeah. So Michael, I have a question here for you.
Yes.
So let's say if I take Nike brand and I make an NFT. So what happened here?
If you take,
I created the cartoon version of Nike checkmark.
okay.
Very similar to the Nike logos, and I sell as the NFT and for all this digital goods I'm selling. So
yeah, so it's an interesting question, and it's whether it's an NFT or whether it's a physical piece of art, the analysis is relatively similar in that, to the extent that the consuming public, the person who's going to buy your NFT, might believe that your NFT, your image with the Nike swoosh, was produced by Nike. Nike potentially has an action as a owner of a registered trademark for trademark infringement, to the extent that that your use is creating confusion in the marketplace as to the source of the goods. Now, Nike, it's a funny example because we're recently involved in a lawsuit involving a use of sneakers that had the swoosh mark, but they were heavily modified. And they were done in, if I remember right, it was some sort of like demonic imagery. And Nike was really upset that it looked like they had been producing sneakers that had imagery that wasn't consistent with their brand. And this is a perfect example of why any company that's using a name, a logo, a slogan as a mark wants to register their trademarks and protect themselves in that way, because you don't want a similar use to start to affect your brand image. Nike doesn't want the general public to believe that they're putting out sneakers that have demonic imagery on them. It's not consistent with their brands. And similarly, and the registered trademark provides that protection.
Mm. Well, I think that actually this subject naturally blend into how do we protect it. So years ago, I took class, business law class, and then the one thing I remember still today is that you can have the strongest case, but if you don't have money to defend it, you're gonna lose the case. So that is the question. I think probably among many founders that have this question is that, well, I can spend the money, I can file, I can build up a really nice portfolio for patents, but if something happens, let's say very large industry leader are doing something similar, how do I protect my own patent? Should I just start a litigation? What can I do with the limited, resources? So I want to start this question, maybe go with Joshua first, and then Ali and James, and then Michael.
Thank you, Lake. So if you're asking, and I believe I heard you correctly, that you're looking to protect your innovation with limited resources, is that right?
So in this case is that, let's say one life science startup build up a portfolio of patents. And then 2 years later, the startup find out a large pharma company might be potential violation of this patent. And what will happen?
Well, that's a great question. And a lot of it, comes down to what the legal answer is, and then what the real world answer is, which often they're the same, but they're not always the same. So number one, if the startup has this patent and sees that the big pharma company is infringing the patent, their first step, number one, is likely to be, well, how well do we know that this is actually happening? Have we done an analysis to see that, yes, they are actually infringing the patent? What are their arguments for saying we don't infringe the patent? Including, how strong is that patent? Is it valid or not valid? Is there a prior art that can be cited against it? what defense would Big Pharma have if we actually got into a fight with them? That's number one. Once you do that analysis and you do that due diligence to see where you are, the next step usually is to contact Big Pharma or whoever it is that would be infringing in a very polite way to say essentially, hey, we have this patent. We respect the intellectual property rights of others. We assume you do as well. Let's talk. The difficulty is you don't necessarily want to be very aggressive, because if you do, you now can give Big Pharma the go ahead to file suit against you first, because they are basically fearing that you're going to sue them, so they could go to court first to seek a declaratory judgment action that your patent is invalid or is not infringed. You don't want that. You don't want to go to court if you can avoid it. You don't want the other side picking the court to go to if you can avoid it. What you're really trying to do is probably one of two things. Either make the Big Pharma stop, or I should say three things. Make Big Pharma stop, make Big Pharma fund you to be a partner with you, or number three, make Big Pharma buy you out. Now, you're the small little startup. How can you do that realistically? Number one, well, you do have these patent rights and there's probably some value to them. And let's face it, Big Pharma these days treat startups, smaller companies as their R&D divisions. They don't do as much R&D as they used to. They get a lot of their new developments from startups that have these new technologies. So that's something that would be in your favor. Hey, let's talk, let's make a deal. Either buy the technology, buy us, anything like that. The other possibility is if that Big Pharma company is not willing or not interested in working with you, there are other Big Pharma companies out there with deep pockets, and some of them would love to buy your patent portfolio from you to have a chip or something that they can enforce against other Big Pharma and let the big boys fight it out.
Okay. Well, so Ali, do you agree with the Joshua's approach?
Absolutely. Yeah, there is, and I really like the way that Joshua put it. There is a theoretical legal way of looking at this, maybe somewhat law school way of looking at it, but none of us here, we've all been out of law school for many years, and the practical way of looking at this is that when you have a patent and that patent covers what you do, whether you assert that patent in litigation or not really depends on where you are as a company and how the other company is impacting your bottom line. And for most, if not all startups, and like you would appreciate this as an investor, no one wants to get into a lawsuit. No one wants to get into litigation. That's an absolute last resort. And I've had companies go through this and many times, and usually when companies hit each other with their patents is when there is a significant amount of revenue, such that they can afford lawyers like us, to deal with all the court actions and so on.
Like Google and Uber.
What's that?
Like Google and Uber.
Oh yes, yeah, exactly. And
Samsung and Apple.
Right, and you raise a good point. In tech, generally, and there are some exceptions like Apple, Samsung, and so on, but generally these big companies don't really sue each other. Whereas in the life sciences, it's a different story. The big companies do sue each other. Like Illumina does and has and actually has sued BGI for infringement, right, of its patents, and so on. And actually the outcome was just last week, and BGI actually has done quite well. So, but in the life science space, companies do sue each other, but such companies are usually at a point where they have a significant amount of revenue at play. For startups, though, we're not talking about suing anybody. For startups, we're talking about preserving value, preserving options. And what that means is that we want to get patents that cover us, our companies, and get patents that hopefully cover the big guys too. And really the pitch is, we're not going to go and sue these big guys. That's absolutely out of the question. But what we're talking about is when a startup is looking for an exit of some type, whether it's going public or more likely an acquisition, then to the acquirer, having a patent that covers the big guys would look very good. it's going to increase the value of the company by so much. And that's what we're really thinking about here.
Got it. And James, in your experience, you see the similar approach as well.
Yeah, I echo Joshua and Ali's sentiments, but I think to add a layer on top, it's about timing too, right? So you might not approach a strategic before the company is well financed, or there's a venture capitalist or another strategic investment that backs the company, so that if there needs to be some type of lawsuit or needs to be some type of claim, you have the company has the funding to take that route. Other times I've seen sometimes the board and IP council really strategize and not share their findings and their strategy until much later when the company is further along. But in board meetings, you'll see that they might show some slides, but not circulate the IP strategy. Or other times when doing diligence in a financing or transaction, the IP strategy might and potential infringement might be communicated amongst the business parties and the IP attorneys, but not be put on a disclosure schedule or be put in writing. So a lot of times that strategy or approaching the strategics or big pharma might come later, as opposed to earlier in the life cycle of a company.
Sorry, I forgot I mute. So Michael, is that the similar situation in copyright field?
In trademark, it's somewhat similar in that in what Josh began with, in that when you find a potentially infringing use, you're going to start by reaching out, most likely politely in most circumstances, to ask the other user to stop, to inform them of your use, of your registration, and that they're potentially infringing on your trademark. Most situations do resolve informally, but there is frequently the need to escalate to litigation. And one of the concerns that you have in the trademark space, and this goes back to something mentioned earlier about the duration of your trademark versus the duration of your patent. The duration of your trademark, like I said, can be it can be in perpetuity, but you do have to enforce your mark in order to continue holding those rights. So, for example, to the extent that a trademark is predicated on your use, you have to continue using it. The trademark is also predicated on the fact that your mark distinguishes your product or service from others in the marketplace. When other companies start using, or other businesses or individuals start using similar marks or using your mark, then it becomes more difficult for consumers to distinguish your goods and services from theirs. If you allow that to continue without enforcing your rights, without sending cease and desist letters, without potentially initiating litigation to stop another party's use of your mark, that can significantly weaken your rights in your trademark over time. And it can happen to the extent that you would lose protection altogether.
So does that make sense to have the trademark portfolio to be reviewed from time to time? Yes,
it's very common for many of our clients that we will monitor the use in the general public of your mark and similar marks. Sometimes that's through a third-party vendor that sends reports anytime there's a potentially conflicting application at the U.S. Patent and Trademark Office, but they're also sending reports about common law uses around the country and domain name uses on the internet. So if there might be a new URL that pops up somewhere that's similar to your business name, your slogan, we'll get reports and frequently make decisions about how to move forward, how to contact those junior users from there.
Yeah.
But for other businesses, we might do something as simple as, a targeted geographical search about, with your mark or in your business space, just to see if there are any new users in your space from time to time.
That sounds like an AI startup idea. To scan the whole internet to see what's considered similar. Okay. I recall Ali mentioned a term called freedom to operate. Right? Can you expand on this? So what is freedom to operate and why is it important?
Sure. Maybe just taking a quick step back. When a company gets a patent around its invention, that doesn't mean that the company can practice what that invention is. This is sometimes not fully appreciated. I've had companies tell me, well, I got a patent around my invention. I should be able to do what that invention is, and that's not correct. And the reason is, perhaps by way of an example, imagine if your invention is a pencil plus an eraser. That's your invention, and you work with Joshua to patent that. You get a patent that says pencil plus the eraser. But there may be someone else out there may have a patent that covers the pencil. And that patent that covers the pencil might block you wanting to sell a pencil plus an eraser. And so that's where we get into this concept of freedom to operate, which is asking the question, apart from us getting your patents to cover what someone else might want to do to copy you. We want to prevent someone from you copying you. But if you want to do what your invention is, what your technology is, are there patents of others out there that might stop you from doing that? And that's what this study is we carefully think about how to structure searches to identify these patents. We very carefully review them to make sure that they don't cover you. And if they do cover you, we think of reasons why potentially they may be not valid, that they may be invalid or help you work around them. So it's actually a very complicated exercise. And I often tell my companies, don't look, because when you look like, when your companies look, and they may not be patent experts, when they look, they may not fully appreciate whether they're dealing with a landmine or not. And so and every company in the life sciences should be asking this question at some point. And then we can help them find a strategy to look for these landmines and how to de-risk those.
It sounds like not only complicated, but also a little bit, I would say, you should be very, very careful because I recall I had a similar conversation with my previous patent lawyer, and then he was saying that, well, if you have conduct tremendous amount of patent search, you read everyone's invention out there, and how do you prove that your idea is not coming from them or is original? I don't know that all of you agree that the statement, but I think that is a question, interesting question, and we'd love to hear your thoughts on that.
The big risk is really with companies who may not be patent experts looking is, look, patents are not written for engineers and scientists. Patents are written for the courts. Any scientist who picks up a patent, most scientists would probably get a headache when they read a patent. If it's done right, you will get a headache. And that's because it's mumbo jumbo. Their claims and their things are worded in a peculiar way. That's intentional. That's by design that we do things the way that we do. But
so
because
Ali, you're saying that you abandon your science major and go pursue a headache-driven career.
That's right. I've been having headaches for the past 16 years. But let me and Joshua and Michael and James have the headaches. For companies, your focus should be on commercializing, building a great therapeutic, building a great diagnostic tool, whatever. It's your focus on the business and let lawyers structure ways of minimizing risk. So don't worry about reading patents. They are complicated, they are confusing. If you do search for patents, and if you don't do things right, you may actually expose yourself to future issues that you would otherwise want to avoid. So that's sort of in a nutshell, let us have the headaches and not you guys.
Okay. Earlier we talked about IP protection, and I think from that subject we can actually branch out how we can monetize IP, right? So Joshua, can you talk about, you actually touched on this a little bit already, IP portfolio monetization. Can you give some examples and suggestions to companies?
Sure, absolutely. So, first, I agree with everything Ali just said about freedom to operate and what that looks like. Why is that important to monetization? Well, again, it's important to remember that having a patent does not actually let you do anything. What it does is it lets you stop others from doing something. Okay, why does that matter to monetization? Let's say you're a biotech company and you have a product on the market. It means you can now command a premium price because you're not facing competition. You can stop other people, other companies from competing with you. That's really what it comes down to. That's what a patent is there for, to stop other people from competing. That's how you get more for a patented product in sales than you do for a non-patented product. That's one way you monetize it. Another way is licensing revenue. This is the IBM model, where you patent everything that you're working on, whatever the technology is, whatever the development is, you get a patent on it, even if you know you're never going to have a product. Why? Because one thing you can do is, if there are other companies out there that do practice what you've patented, you can stop them from doing that unless they take a license from you and agree to give you some milestones, some upfront payments, royalty, reasonable royalty percentage of what their sales are. That's another way to monetize your patent. A third way is just to develop a patent portfolio for your company, like we were talking about earlier, and then put it all together as a package to say, hey, big pharma, let's buy my company now. And maybe it was worth 100 million before I had these patents. Now that I have this whole patent estate, it could be worth $1 billion because we have the ability now to stop others from competing with you. Those really are the three main ways to monetize patents, especially in the biotech sector.
Which method do you see more often than the others?
For startups, what I see most often is the way where you generate patent estates, generate a patent portfolio, and you build company value that way with the idea that someone's going to buy you out eventually. Because let's face it, if you're in the biotech sector, aside from the patent issues and aside from the technology, you have the regulatory pathway you have to get through also.
Right.
And for you to be able to get a product on the market, you have to make it through the FDA and spend, let's face it, 9 figures to get there between now when you start and when you actually have a product on sale. That's an awful lot of money. And I know very, very few startups who can afford to go that route. So you develop your patent portfolio, you make yourself attractive to big pharma or big biotech, Amgen, somebody like that, and you wait to get bought.
Yeah, okay. So I know I got a reminder that we have 5 minutes left before we can go to Q&A. So I have one question here for all of you. So there was so much talk about there are a lot of work that lawyers are doing can be replaced by automation or AI. And I have met a few startups that try to do this, particularly for patent creation. So I'm going to ask you, in the next 5 years, what do you think part of your work that you would like to see to be replaced? And what kind of work do you think that you think that we're never going to be replaced by AI?
Start because The corporate side's much easier than the patent side when it comes to bio. Our firm has already started to replace some of our routine work with document automation. So we automate the formation process and even the first drafts of financing documents. The benefit of that is, and then even some of the signing and other processes. So that takes out a lot of the administrative and routine work, so that then the lawyers can focus on providing like the in-depth and advice and the actual strategy. So that's one way that even though we're a large law firm with expensive rates, we cut a lot of the busy work and the routine work. But as much as we can do that on the corporate side, I'm going to defer to the rest on the patent side and IP side, which I think might be more difficult. But I'll let.
Okay, who wants to go first?
I'll go next, if it's okay with the others. And James certainly is very humble, but the corporate work is also very, very complex. There are some things that can be automated, maybe at the lower level, but when you get into these complex deals and so on, we're years upon years away from that being automated. And on the patent side, I've actually used companies. I actually took a shot at using a company that told me that they can give me a first draft of some application that was AI generated. I thought, okay, cool, let's check it out. Worthless. It was super worthless. It was a waste of money. And in fact, at the end of the day, this company hired an agent to write a first draft for me anyway. And Josh is agreeing with me. The reason, guys, this is that with patents, there's an art to drafting patents. It's art. There's a way that we draft claims that's carefully structured to look thick and narrow, but it's at the same time broad and aggressive, and it's clear of the prior art. It's novel, and it meets all these statute hurdles that can't be trained within our lifetimes. And I'm not just saying that because I'm trying to preserve my career. That's just the reality. What Joshua has done for years and what I've done for years, we have all this experience knowledge base that we have in terms of examiners at the patent office and their art units and their allowance rates, what keywords they like, and that kind of stuff that you can't train that. Maybe there's a basic way to prepare a first draft, a very rough first draft that has to be very carefully then used as a starting point. But in terms of automating patent drafting and getting patents, if you guys are working with a company that says that they can do that, please take a very careful second look, because you ultimately might regret using this when it comes time to actually get financing or getting acquired.
All right. So, Michael, what do you think?
Without speaking to the patent side of things, where trademarks are concerned, the applications are far more straightforward and less artistic than the patent applications. And I think it would be, to a certain degree, beneficial to automate more of the drafting of the application process. And I could see that happening in the trademark space. One thing that I would love to see, and I don't know how soon we're going to see anything that's very usable. I know that there are some inroads being made, but I would love to see more predictive litigation outcomes that we could use to better guide our clients when they're trying to determine whether it's worthwhile to pursue litigation, or even within, I'm sorry, my lights have just gone off because I'm sitting still too long, whether a certain motion might be worth filing or pursuing based on the possible outcomes of that motion. And that could be taking into account factors like the particular judge that you might be in front of, your mark versus your competitor's mark, the marketplaces that you exist in, the sophistication of your customers. There's a lot of information that needs to go into making that type of prediction. And we rely on our experience and on the case law that we're familiar with to make our own predictions. I think it would be helpful to have the power of AI to give us more information and more ability to predict those outcomes.
So Joshua, do you have anything to add?
Yeah, first, I agree with just about everything Ali said. It's one of those things where you get what you pay for. You really do. And, I saw this 10, 15 years ago when there was the big movement to offshore everything to other countries, whether it was searches or patent drafting. And I had clients who did that, tried it, and showed me the results. And they weren't anything I would have felt comfortable putting my name to, I'll tell you that. And you're seeing it now with AI. There's always this big move to save money, to make things more efficient. I think there are ways you can do that. You can use AI effectively to do that, but drafting your patent application, at least right now with the technology available, not a chance. It's more of the ministerial tasks. How do you get all the documents together? How do you docket things properly? How do you make sure that references that were cited in related cases are cited here in the US in your case? All of those things are great uses of AI and definitely increase efficiency and decrease costs. Every practitioner I talk with thinks that AI is coming. AI will be here and will impact what we do and how we do it. But we all see AI as something that helps us focus more on those high level tasks like drafting an application, responding to an examiner, developing claims of large or smaller scope, rather than having AI do those things and having us be out of a job.
Yeah. All right. I heard you loud and clear. You get what you pay for. So we have a question here from the audience from Alex Lowe, a very specific question. So what is a practical strategy, legally and beyond, for commercializing IVD technologies in China, given the current US-China relationship? Any recent success stories? Thanks. Who wants to take it?
I can go if people don't mind. Honestly, I don't think the relationship between the US and China is as relevant. China has a reputation, which I think personally is unfair, of being a very difficult country to commercialize in, of being very unfriendly to non-Chinese entities. And I just don't think that's true these days. I think the Chinese courts are very friendly, are willing to uphold patents no matter who owns them, are willing to say, no, you can't do what you shouldn't do. This is the law. The law is the law. The problem is more one of culture, where I have clients in China, and I have one Chinese client that has manufacturing operations in China. He talked to me about 7, 8 months ago now, tells me about a big problem he has where he's making product hand over fist. He can't sell enough of it. And yet, his sales weren't increasing the way he thought they would be, only to find out that his foreman at his plant was operating the plant at night without his knowledge and selling those goods that were actually, the same goods as he was selling under his own name. That's a cultural issue rather than anything else, right? I think that's where the real problem is in China, the culture, and it's going to take some time to change that culture and that mentality. But I personally think China's a great market. I think they do respect intellectual property. You can see that by how much money the government is investing in IP, how many patents are filed for every year, how many trademarks are filed for every year in China. I just think it's going to take some time.
Yeah, I recently saw a chart that shows the number of patents that filed by country, and US and China are definitely top 3. Yeah,
definitely, without a doubt. And China's been number 1 for a few years. A lot of people say unfairly because their government gives Chinese companies money to file patent applications. Whether it's fair or unfair, I leave that to others. I'll just go by the simple fact, people are filing patent applications in China.
Well, I have a related question here. So that's assuming that you have a company that is research is done in the US and want to expand to China, and then you have some application patents there as well, right? So, and I got this question quite often: is where should I file my patents? Should I do multiple markets or primary, and how do I protect my patents if I file outside of the United States?
Sure, I can take this one, Joshua, if that's okay with you. You know, when you file patents outside the US, things get expensive pretty fast. And it's not because of our fees. It's not because of my fees or Joshua's fees. It's because of what you pay to these various countries and governments, regions, what you pay for in terms of taxes, these things called annuities, and so on. But there's a very nice way to preserve options as a startup while kicking the can downstream, such that you guys have raised money to be able to pay for these expenses. And that's by filing a PCT, patent application, Patent Cooperation Treaty. It's a very nice way to preserve the opportunity for a year and a half or so, roughly. You know, you have from your very first filing, you have 30 months until you have to file in various countries, and the PCT route gives you that option. There's a $5,000 filing fee that you pay to a patent office, is roughly, plus or minus. And by the time that you have to file in these various countries, you can then use that as a jumping off point to file in China, in Europe, in Japan, in the US for sure, Canada, Mexico. Most countries you can file in from the PCT. A few countries such as North Korea, Iran, and so on, these are countries that are not very common, but most countries that will matter to us in the world that we live in, you can file from the PCT. Regions like Taiwan and Argentina, you can't, they are not part of this treaty. And for those, you have to file separately. But that's the way to really do this. And now sometimes I have companies ask me, where should we file? And that is it's certainly a function of your budget, but it's also a function of what industry you're in specifically. If you're a therapeutics company, you have to file pretty aggressively. You have to file, in Europe, and then you have to then have it registered or validated all over Europe. You have to file in China, Japan, Australia, really almost everywhere. But if you're a tools or diagnostics company, you're really thinking about mainly the US, Europe, China, and Japan. Those are my top 4 tier 1 markets. And then if funds permit, I like to throw under Canada and Mexico because they border the US. I like to include Australia, maybe Israel, and some other countries. But your top tier 1, US, Europe, China, and Japan, if you're a tools or diagnostic company, would be those. And in therapeutics, you really have to file everywhere.
And why is Japan?
Japan, because they have a well-structured healthcare system. So they have the reimbursement model and so on.
Okay, we also have a question from Michael He. So this is for Michael. Michael mentioned the color can be registered. The question is how to avoid abuse of the patent registration.
How to avoid abuse?
Abuse of registration. Well, I think it's a waste of our own money, right?
Yeah, so I'd agree with that. I think it is in that degree sort of self-regulating, but there is also, in order to register a trademark, you have to file an application with the United States Patent and Trademark Office. And once you've filed your application, the application will be assigned to an examiner. The examiner will look at your proposed mark and go through a variety of factors as to whether or not it is something that can be registered. And some of those factors might involve prior use by another similar mark, but it may also just go to whether or not it is something that can be registered to begin with. So that's typically something that the PTO will handle. If it's something that there's some reason for them to refuse, you'll get what's called an office action from the PTO. You'll have an opportunity to respond to the office action. There are X, Y, and Z reasons why my mark should be registered and allowed. And there's also an opportunity for other users, typically prior users, to oppose your application. so there are mechanisms for avoiding abuse, but I think your suggestion might be the most practical one in that it is likely just a waste of somebody's money to go that route. Later on, if there is, if there are competing interests in a particular color or smell or any other legitimate mark, there can be arguments raised through litigation about the validity of one mark or another.
Interesting. Well, I also have a question here for Ali. For small molecules and antibodies, it is clear, but how to protect biological targets? Mostly it is ambiguous. What is the best way to do it?
So that's a great question, and you're really thinking about for a therapeutics company. What really matters is having the data to show sort of efficacy and whatnot, and sort of that it does work for its intended target indication, and preferably we're thinking about actual in vivo data versus in vitro. So once you envision having data within 1 year or less, then is the right time to get a patent application on file. In the US, you can use the provisional route to get that on file, and then you can update it with the data when it's available. But you would then structure these things called claims to cover whether it's a small molecule or an antibody that has specificity for a particular target region of the genome, for example, or if it's a CRISPR-Cas play, whatever the therapeutic is, you can then structure claims to cover that from various angles, from composition of matter angles and also method of use angles.
Another question from Helen Ma. Can you comment on the differences by IP strategies for technologies from universities versus from companies?
Well, I work with a lot of companies as well as a lot of universities, and there are going to be a lot of similarities between what they're doing, but there are going to be a lot of differences also. So companies, for the most part, are going to be much more focused, right? They're going to have one or more products that they're looking to develop, and their IP is going to be focused on how do we protect those products. For universities, you have a lot of different considerations. You have your researchers who want to publish, and you don't necessarily have anything that's commercial unless you have a startup coming out of the university or spin-off, something like that. A lot of universities will, one, try to patent things that they think they can sell, because of course the university is never going to make anything on their own. So they're not really going to be focused on what can we commercialize, but what does the market want? What do other people want to commercialize, and how do we give that to them? And then sometimes if you have a key researcher or the big name on campus, you'll give them whatever they want, because quite frankly, you want to keep them happy. Even if it involves patenting something that has no commercial value that you can't monetize, if that's what it takes to keep that researcher happy and at the university, you're going to do it. A lot of it comes down to how strong is the tech transfer office, the TTO at the university. Do they have their act together or do they not? Because some of the universities I work with, they have a really strong tech transfer office and they're very tight and focused on what they want to protect. Others, they either don't have a tech transfer office, they have somebody junior there, and that's more like the Wild West. Anything that comes across their desk, they're probably going to say, okay, this is fine.
What are the strongest university that you've been working with on this?
Well, I mean, if you look, there are a lot of different ways to measure it, either by number of patents, by revenue derived from patents, by number of filings. So there's no one list that says this is the strongest patent. But if you look at who generates the most revenue from the patent portfolio, you have places like Stanford University, Northwestern University, here on the East Coast, because I'm in East Coast, there's MIT, places like that. And they're not all in the US either. You have a lot of universities overseas. Think Oxford in the UK. You have some universities, quite frankly, In the Middle East, King Fahd University of Petroleum and Mining is always one of the top filers as far as actual numbers of filing out there. So there are a lot of different ways of looking at it. Not one size fits all. A lot, do you go to the US News rankings? Do you go to other rankings? And then also, what's the purpose of the university? Is it a pure research institution where they want to protect the research? Are they interested in the numbers for reputation? Do they want to develop revenue for the university? Not every university does it the same way.
That's a really good tips. Let's say if there's a company, let's say want to collaborate with the university, and then I think that's the homework needs to be done, right? Just looking to technology transfer office and how knowledgeable they are, how they work with other companies, and before you get involved too deep. Okay, so I have another question here for James. Interesting. So as we know, the most valuable skill is in the brain, and employees keep changing jobs. As a company owner or founder, how to protect IP from talent, basic talent taking your knowledge to some other companies.
Yeah. So, and this is on the corporate side. Whenever a company onboards an employee or a consultant, they should be signing a PIA, or a confidentiality invention assignment agreement. And these provisions, these are standard provisions that are integrated into every at-will employment agreement and consulting agreement. It should be, at least. So now anything that is developed or is disclosed, or the employee or consultant comes across during the course of their time at the company, is number one, owned by the company, and number two, protected in purposes of confidentiality. So now when this employee does change jobs, they're still bound by the confidentiality provisions in these particular agreements. One thing to note, that in California, non-competes are unenforceable. So that's in maybe other jurisdictions that might block particular people from practicing the same technology or area in with competitors, but at least in California, those non-competes are unenforceable in California.
Is there expiration on those terms? That, for example, the employee start a competing company, let's say after 3 years, law have changed in 3 years, right? So is there a reasonable amount of time that you put on that non-compete confidentiality?
Yeah, so non-competes, I outside of California, I might see sometimes 6 or 12 months, but a lot of times that those get negotiated out. And then for confidentiality, they usually last in perpetuity. That that might be different than a non-disclosure agreement. Some non-disclosure agreements might have 1 or 2 year terms, but for employment agreements and confidentiality agreements, that confidentiality may run for the course of the statute of limitations. And that's because you wouldn't want an employee to be exposed or contribute to something that's confidential and then take that confidential information and start their own company or bring it to a competitor.
Okay, so I think this is actually, we're looking to from the other side of the table, right? So looking from a founder perspective, how do you want to protect your confidential information and inventions? But in the meantime, and if you are an employee currently thinking about starting your company, then the recommendations, make sure you read your employment agreement carefully to understand what you're doing, right?
Another thing to do is to sometimes have a break from maybe if somebody's employed at their current employer, to resign and have a break from when you're employed with that company, spend a few weeks off, and obviously don't bring any confidential information or don't download any trade secrets, and
Don't
sensitive.
use your company property.
That's right.
Time,
Don't take
computer.
screenshots or things like that.
Yeah.
And then you start your new company a few weeks later after you've taken a break, and then then at least there's like a clean break for purposes of IP. Oftentimes, people may even come to us and get some trade secret recommendations before they even leave their current employment, just to follow the protocol and so that they're not tripping up come when they start the new company that might come out in future financings or IPOs or acquisitions.
Well, here comes the question for trade secret. This is a question for Ali. So can you give a failure example of trade secrets?
Yeah, I'm sure everyone has heard of the mess with this one engineer who left Waymo for Uber.
Yeah.
And that guy took, this is, come on, this is just blatant, just took the data and whatnot from Waymo over to Uber, and you can't do that, but I suppose I guess what's meant by failure, but we've discussed some of the risk with trade secrets. The risk being that if what you're keeping as a trade secret, if your invention is invented by someone else elsewhere, or if it's published by someone else, whether they stole it from you or they did it independently, your trade secret goes away, it evaporates. And then you would have to go and if they stole it from you, you would have to go and sue them for what's called damages, for whatever the value of the trade secret was and how that impacted your company and so on. It gets very messy. So that's the risk, is if all you're doing is keeping your inventions as a trade secret, be aware that someone could independently come up with it. It might be reverse engineered. If you sell a product out there, it might be reverse engineered and so on. But apart from that, and this is kind of touching on what James mentioned about sort of having PIIA signed, we want to make sure that your inventions can't be readily moved from one company to another. They can't be leaked. So if you are keeping your certain aspects of your inventions as a trade secret, you want to make sure that anyone that has access to it is under the obligations of confidentiality, to keep that as a trade secret.
Right. Well, I can't believe we already talked for 1.5 hours at this point. So it's coming to the end of this webinar, and I just want to ask each of you to give one piece of advice in one sentence. Can you do that?
I'll just go first. Don't take shortcuts with biotech companies. Otherwise, 3 to 7 years of your life could just go down the drain. So don't take shortcuts.
All right. Joshua, so what you get and what you pay is what you get. Are you gonna say that?
I used that already. I'll come up with a different one. Know where you're going, or wherever you wind up will be fine. You have to have an end goal in sight. You have to have a clear direction, a clear plan. If you don't, you're just going to be floundering and you're going to wind up anywhere. You're not going to be happy with the results.
All right, thank you.
I would throw in there to not act alone. Throw your ideas off of somebody else, whether it's an attorney or another experienced person in your field, or even somebody far away from your field who might have insight that you're not thinking of. Don't go at it alone, whatever it is.
All right, Ali.
And fully agree with everything that's been said. But when it comes to your ideas, assume that all of your ideas, regardless of how special you think it is, assume that they're all important, and talk to one of these experts here, us, about how to protect those.
All right, great. I think you guys are all very good at coming up with one sentence. With that, thank you everyone. So thank you, Michael, Ali, James, and Joshua for your precious time. And I want to also thank Huey to give this opportunity for us to talk about a subject that's everyone can relate it to. So with that, I'm giving back to the mic to Dan.
Okay, thank you everyone. Thank you, Lake, for the moderating of this event today. And I appreciate everyone's support to our training series. And I hope we can bring more informational events in the future for everyone. Okay, thank you and look forward to see you next time.
Thank you all.
Thanks, everyone.